Good morning, ladies and gentlemen. After I received from the international press, after I posted a blog regarding the miscarriage of justice concerning a Maltese citizen, namely Mr. Charles Farrugia. These are the events that took place of this shameful event that should have never have taken place. This all started back on the 29th of January 2002, when there was a hold-up in the premises of Mr. Farrugia, and himself is a victim of a hold-up. Immediately the police started investigating the case. The case requested a magisterial investigation, and late in the evening of that day they informed the magistrate that that there was no need for the investigation to continue because they said they had solved the case. Wow. In few hours, within the same day, the police already came to the conclusion that they solved the case. Consequently, the police have arraigned Mr. Farrugia to court, and he was charged with wanting to fraud an insurance company. The case at that time went in front of then magistrate and later judge Antonio Mizzi. The case heard in front of Magistrate Mizzi found Mr. Farrugia not guilty of all charges, and rightly so, because the police have used only one witness, a shady witness, which he changed his testimonies 3 times in court. And I am saying a shady witness. Later I will explain why and how. When Mr. Farrugia was acquitted, the Attorney General at that time had filed and contested the case. He made an appeal in which the case then went in front of Judge Galia De Bono. The case being heard by Galia De Bono had flaws from the beginning. Galia De Bono himself never listened to either live testimony or recorded testimony of Mr. Farrugia or any other person. Galia De Bono, in few days, he came to a conclusion without even reading the file he had in front of him from the previous court. He never listened to the tape done by the police while questioning Mr. Charles Farrugia himself, listening to the only prosecution testimony, the prosecution themselves. Mr. Gallia de Bono not even listened to the shaky testimony that he have changed his testimony 3 times. First, he came to the conclusion, the testimony came that the person that testified, which himself faced court proceedings and found guilty, said that there was no hold-up whatsoever. Then he changed his version that Mr. Farrugia wanted to fraud the insurance company when there was no insurance. Thirdly, he changed again his testimony, saying that Mr. Farrugia wanted to close his business, when at that time Mr. Farrugia himself was dealing in contracts regarding 1.6 billion dollars. Mr. Gallia de Bono never listened to these things, never heard Mr. Farrugia himself. He changed part of the sentence of Magistrate later Judge Mitzi and found Mr. Farrugia guilty without listening to nothing, without reading nothing, without hearing the tapes. He came to the conclusion and attributed things that they were not in the file or in the case, but Mr. Gallia de Bono have attributed things that they were not there, were not involved in the case, but found Mr. Farrugia guilty. Mr. Farrugia then, after this charade, filed a constitutional case for not having a fair trial. It is understandable when a person is not being asked or give evidence in front of a judge, neither the police, neither the shady and shaky witness. He came to the conclusion that he said himself he believed what the police said, but he couldn't believe Mr. Farrugia. And came to the conclusion again, telling you once again, found Mr. Farrugia guilty. Mr. Farrugia have resolved himself for a constitutional case for not having a fair trial or hearing. The case in front of the Constitutional Court went in front of Judge De Gaetano, Vincent De Gaetano. When Mr. Farrugia and his lawyers learned this, they've asked Dr. Vincent De Gaetano, the judge then, to recuse himself from hearing the case, but said judge refused to do so. This was done by Mr. Farrugia because Judge Vincent De Gaetano was the judge that he heard the appeal of the shaky witness, in which he found him guilty. In fact, he upheld the sentence that he received from the lower courts. When Mr. Farrugia, through his lawyer, asked Judge Vincent De Gaetano to recuse himself from hearing the case for unfair hearing, Mr. Farrugia had once again had to file another constitutional case in order for Judge Vincent De Gaetano to recuse himself from hearing his case. When this happened, and Vincent De Gaetano heard about it, he suddenly recused himself, and the case went to another judge. When the case continued, it was noted clearly that the police interrogation tape had vanished. And this is not the first item that was vanished from the law courts. At the law courts, there was a safe that was seized from the premises of Mr. Farrugia, in which, in the same safe contained a large sum of money and important company documents and other personal documents of Mr. Farrugia and his family. This safe mysteriously disappeared from the law courts as well. And until today, Mr. Farrugia cannot retrieve these items, which are of great importance for his cause. It is shameful that these things happen and happened, and they should never have taken place. In 2013, Mr. Farrugia, after he had went through all the stages in the Maltese judicial system, he registered a complaint with the European Court of Human Rights for unfair hearing, stated that he was not given a lawyer during the police interrogation and only been given the normal police caution. The case came in front of the ECHR, European Court of Human Rights, and the prime judge, the vice president judge, was Vincent De Gaetano. I would have understood that coming this particular case in front of him, and this is only my opinion, I do believe that if this case came in front of him, he would immediately have recused himself from hearing this case and pass it to another judge. There were 7 judges, so with one less judge would have made no difference whatsoever, but ethically and morally, Judge Vincent De Gaetano should have resigned and recused himself from hearing this case. In this case, he kept on doing the job as nothing would have happened. As I explained to you, it would have been morally his duty to recuse himself. The case continued, and here we come to the most terrifying of learning and reading the sentence that Judge Vincent De Gaetano, let me give you the number of the case. The application number is 63041-13, case of Farrugia versus Malta. Vincent De Gaetano plus 4 more judges have made the biggest mistake, and they tried their best to try to explain that there was no miscarriage of justice, there was no breach of human rights of said Mr. Farrugia. Too much cases were brought forward, and they've tried to explain and go around those cases, in which in those cases one of them was quite similar for Mr. Farrugia, and he was found not guilty. But in Mr. Farrugia's case, the judges have linked various mistakes, have went around a lot of what they tried to explain, in which the president of the Human Rights Court with a female judge could not agree with the sentence handed down, and immediately on the same day, on the 4th of June 2019, there was a joint dissenting opinion of judges, SERGHIDES and PINTO de ALBUQUERQUE. 2 senior judges did not agree with the sentence. They were against the sentence, and in their explanation, which was handed down on the 4th of June 2019, have extremely went paragraph with paragraph explaining how the 5 judges that were the prime judge was Vincent de Gaetano, were not right in their sentence. They went against the human rights. They broke the human rights of Mr. Farrugia, in which I go to the conclusion of the report, and it reads like this. When I go out of the report to say something, I will tell you, so you don't get mixed up. And then after, I will read the conclusion alone, so I will not mix you up regarding what I had to say. This is a truly Kafka case. Kafka was another case similar to Mr. Farrugia, and he was found not guilty, in which an already acquitted defendant ultimately finds himself convicted on the basis of a shaky testimony from one single prosecution witness. That's why in the beginning I told you they only stayed on one shaky testimony. Remember, he changed his testimony 3 times during the court proceedings. That's why Antonio Mizzi saw that there was no credibility witness, and he found Mr. Farrugia not guilty, and they say in their conclusion, an already acquitted defendant ultimately finds himself convicted on the basis of a shaky testimony from one single prosecution witness, and the appellate judge's doubts regarding the credibility of the defendant's reply to police questions concerning facts unrelated to the imputed offense. These judges based their findings and sentence on things that the police were asking Mr. Farrugia, that they were not related to the case, that they were not in the case itself, but the judges wanted to take in kind that and move away from the substance of the case. We were already persuaded that under the first approach, his conviction should not stand. His conviction should not stand. It is clear from the above analysis that all the arguments used by the majority in applying the second approach are unfounded. So all that was written in the sentence from the 5 judges, the president of the Human Rights Court together with a female judge is telling them clearly that they are unfounded. After concluding this analysis, we are further strengthened in our firm conviction that there has been a violation of Article 6, 1 and 3, subsection 3 of the Convention in the present case. Article 6 is that if a person has not a lawyer present with him and he is denied that right, they will be breaking his human rights. We would obviously award the applicant a sum in respect of non-pecuniary damage. That's how it ends. Very soon I will read it out for you again, but I will not intervene out of it. The judges are convinced, like the judge that at that time was a magistrate, that Mr. Farrugia is not guilty, and it is clear here that there was a miscarriage of justice, an injustice done not only to Mr. Farrugia himself, but all his family. And these are not mistakes. As when the case went in front of the Human Rights Court, and this case came in front of Judge Vincent de Gaetano, he should have recused himself and not be part of this shameful sentence issued by them. That same sentence has been clearly condemned by the President of the Human Rights Court, together with a female senior judge. These are judges that they are selected from their countries to go represent their country in the highest court regarding human rights, and themselves have broken the law by denying a fair hearing to Mr. Farrugia. Consequently, the trauma that Mr. Farrugia is still going through should be addressed immediately. Now let me read for you the conclusion without I intervene in between. The conclusion reads this: this is a truly ALBUQUERQUE case in which an already acquitted defendant ultimately finds himself convicted on the basis of a shaky testimony from one single prosecution witness, and the appellate judge's doubts regarding the credibility of the defendant's replies to the police questions concerning facts unrelated to imputed offence. We were already persuaded that under the first approach his conviction should not stand. It is clear from the above analysis that all the arguments used by the majority of appalling the second approach are unfounded. After concluding this analysis, we are further strengthened in our firm conviction that there has been a violation of Article 6, 1 and 3, subsection C of the Convention in the present case. Having found such a violation, we would obviously award the applicant the sum in respect of non-pecuniary damage. It is shameful, it is disgusting that a person, a Maltese citizen, had to go through this, that the miscarriage of justice started from Gallia de Bono, grossly handled at the Human Rights Court by Vincent De Gaetano, and I urge you, the international media, to look into this. This case is well documented. You can find all related material online. You can find and read the sentence from the Human Rights Court. You can find the joint opinion of judges PINTO de ALBUQUERQUE and SERGHIDES, which are senior judges, in which they are saying that the 5 judges headed by Vincent De Gaetano have clearly violated the human rights of Mr. Charles Farrugia, that until today is still suffering an injustice and miscarriage of justice that should have never happened. I don't only urge the international media to intervene. This is a very serious case. This is a miscarriage of justice that should have never happened. We are listening now from the same Human Rights Court, and a lot of cases are being in favor of the appellants, that when they are not given a lawyer while being investigation is a gross human rights breach, and it does not constitute, like Vincent De Gaetano stated here in the sentence, that if the police gives you the caution before interrogation, does not substitute the lawyer. I, as an ex-police sergeant, I know perfectly well that if I cautioned a suspect and he asked for a lawyer, it was my duty to inform the lawyer of his choice in order to be present while being investigated. It is a gross breach of human rights. It's not a mistake done by the judges. These are all judges that served on the bench in their countries. They were chosen explicit by the government for the long service in the judiciary system, and I don't believe that this was a mistake, that they could have done a mistake regarding this case. I urge that a solution will be found. I am believing that the lawyer that took the case to the Human Rights Court have wrote to the court, but until today they haven't received an answer from the Human Rights Court. I don't know exactly the procedure. I cannot understand why there isn't a body that you can go and complain to, but I do believe that the lawyers did send some kind of a letter or complaint to the Human Rights Court, but until today I've been told that no answer was given to Mr. Farrugia. I do hope that justice will be done, justice will be rectified, and justice would be made with Mr. Farrugia and his family. Thank you for listening. Thank you for your hearing. I did it in English because I was told that it was imperative that I will explain everything in English. Thank you very much for hearing me. Remember, I am not an expert. I am just a normal citizen that I get upset when I see a miscarriage of justice of this kind, and I urge that action will be taken immediately. Thank you for listening, and goodbye. My name is Edward Falzon. I live in Malta, and I am happy to assist anyone in giving the information I have regarding this case. Thank you very much. Justice should be done with Mr. Charles Farrugia and his family. Thank you.